Welcome, everyone. My name is Kelvin Ho, and I'm co-director of the Center for Medical Ethics and Law, which is a center that's jointly managed by the medical school and the law school at the University of Hong Kong. I'm also associate professor with the Department of Law at HKU. So a warm welcome to everyone. So we're testing a new format. So if you choose, you're welcome to have the visual. So you'll be able to see all the speakers, and including yourselves, if you should activate your video. This is to allow for participation subsequently, should you have questions to present to the panelists. However, of course, if you choose not to use your camera, that's fine. You're also welcome to present your questions through the chat function. So please feel free to do that either at the end of the panel presentation. So we have two panels as you see on the schedule. First panel comprising 3 presenters, and then a short segment for Q&A followed by the second panel. So we're very privileged to have contributors to 2 very important works, as you see in the description, of one of which, of course, is being addressed in the first panel, and that, of course, relates to the very important topic of relational autonomy. So this edited monograph is led by Father Joseph Tam, as you see on the screen. So he will be a panel member in the first panel, together with 2 other contributors in that edited volume. In the second panel, we have another important work, and that's medical decision-making on behalf of young people. So that, of course, is an important work that has received quite a few reviews, very positive ones, I'm glad to say, and that edited monograph has been led by Professor Imogen Gould. We will be hearing from her at the start of the second panel, and then we have got 2 wonderful colleagues, one joining us from Singapore, bringing in a medical social work perspective, a reflection, as it were, on the important work that Imogen has put together. And then we also have a geriatrician, Dr. Derek Au, who is also the director of the Bioethics Center at CUHK, who will also be sharing his perspective on this particular edited volume. It's of course not meant to be a clear segmentation. Presenters are welcome to comment on both works, and I believe that they will. Of course, the notion of autonomy is relevant to both edited monographs. And of course, we very much welcome participation from all of you in terms of any thoughts, experiences that you may want to share, because as you would have noted from the description, we draw quite heavily on context. Of course, the context itself will relate to the cultural dimension, the social dimension, of course, the religious dimension as well, all of which very, very important in terms of medical decision making. So with this, it's my great privilege to introduce my colleague who will be chairing the first panel, and that's Professor Gilberto Leong. As you see, Professor Leong is professor in clinical neuroscience and associate dean of teaching and learning at the Li-Ka-shing Faculty of Medicine at HKU. He is, of course, also the president of the Academy of Medicine. So it's over to Professor Leong. Thank you.
Thank you so much, Kelvin. Good evening, everyone. Thank you so much for joining this webinar. We have over 200 registrations received, and we have now about 100 on board. I'm sure many will join us momentarily. So the first session I have the pleasure of chairing would consist of 3 speakers of 15 minutes each speech, and we'll have the Q&A session towards the end of the webinar. And the first speaker would be Father Joseph Tam, who is professor of the School of Bioethics of Regina Apostolorum, Pontifical University of Italy. He's going to talk about healthcare decision-making, cross-cultural analysis of the shift from autonomous to the relational self. Father Joseph Tam, please.
So I'm going to share my screen.
Not yet, but...
Not yet? Okay. Shall I share it now?
Yes, please go ahead. Yeah,
Okay,
yeah,
go
we
ahead.
don't see it yet. Yeah, thank
All
you.
right, so. Okay.
Okay, thank you.
Hello, everyone. So this is one of the chapters in this book that Calvin mentioned. And this book, this chapter talks about the relationship between the shift, basically, of informed consent from a way of looking at informed consent of autonomy being something individualistic to autonomy being more relational. As we know, this is the case that I want to present at the beginning. It's actually from Professor Edwin Hui, which is also a professor at the Hong Kong U many years ago. And this is an interesting case because it's about a man Chinese man with schizophrenia in Hong Kong. And in this case, he refuses to take his medications. He's got paranoia. And then his mother decided to covertly give him his antipsychotic medications by giving him soup. And being a good Chinese son, he would not refuse his mother's soup. But then mother ran out of medications. And so she went to the doctor and asked the doctor to continue to give her the prescription so that she could give these medications through the soup, right? And so what should the doctor do? Okay, we get back to this case at the end. And it has something very, very cultural to do with this in the sense that if you apply only the autonomy from the Western concept, you would say that, well, she should stop doing this, right? But then if you look at it from more like a mother-son relationship and also the Chinese way of saying that, okay, the man is taking the medication, even though he didn't know that he's taking it, it may not be such a bad idea, right? So there's a very interesting cultural element to this case. We get back to it at the end. Okay, so most of you have studied a bit of this history of informed consent, and at the beginning of the 50s or 60s, the traditional way of looking at this question is what they call medical paternalism, where a lot of times the patients would just let the doctors decide for them, right? And they would not make so many fuss or demands as to what kind of treatment they would receive. They would just trust the doctors. And then in that period of time, there were known abuses, especially in America. And so it became increasingly a problem that the patients' rights movement and legal challenges to these kind of relationship gives a predominance of the subjects to decide, right, as to what kind of treatment you should get. And here we know that the 4 principles arose from that, either from this National Commission and also from the famous work by Childress and Beauchamp, with 4 principles being formulated, especially the one that has the most relevance to our talk today is that of the principle of respect for persons and informed consent. Here, once again, I won't go into all the details, but since the beginning of the 60s, 70s, there's been a lot of discussion about these 4 principles, and especially about the role of autonomy and in a way translated to patient self-determination, patient deciding what is best for them, not the doctors, and no one else has a say as to what is best for the patient. Only the patient himself or herself knows what is best for him or her. And at the same time, the question of the other principles of beneficence and non-maleficence seems to be less of a prominence, importance as autonomy. So some authors talks about the tyranny of autonomy, autonomy trumping everything else, all the other principles, and the doctors must in some way fulfill the requests, any requests of the patients, even though the doctor might think that this is not the best thing for the patient. If the patient requests it, then a lot of times the doctors would have to yield to these requests. At the same time, along with autonomy and informed consent, became a standard practice, especially in the West, but also in most modern day medicine, this concept of informed consent, that the patient has to make a conscious consent to the treatment or medications or clinical trials that they undergo. They have to sign the paper, they have to be informed by the researcher or the clinician about what they are going to undergo, and then they have to give an explicit consent to that. Now, this in theory seems very reasonable, but as we all know, those who work in medicine, a lot of times it becomes a piece of paper that the nurse shove it in front of the patient and says, sign here, because it becomes a legal document and nobody can really understand all the implications. And doctors do not want to scare the patients and tell them all the major side effects, right? They just say, okay, just sign here and that's it, right? So informed consent becomes more like a legal requirement and not really a true consent, in the sense that the patients really don't know what they're signing because it's too complicated, or the patient does not have the mental capacity to understand what they're undergoing. And they rely on that fiduciary relationship with doctors. Maybe they just say, okay, I trust the doctor and I will do it. So informed consent eventually becomes very formalistic, become a piece of paper, and it seems to defeat the purpose of truly informed consent. So in recent years, there's also been many discussion about the fact that we should not look at autonomy just as an individual rights, as an exercise of individual free determination without taking into account the background, maybe the family members, maybe the beliefs or the culture of these patients. Because as the saying goes, no man is an island. Nobody lives in a truly atomistic type of autonomy. So there is a new, I guess, concern or even paradigm talking about the fact that we need to be much more aware that autonomy is not as simple as we used to think, as an individual making all the decisions. So here, there are many, many different aspects to this kind of autonomous decision by the patient. To rely to the patient, how much truth should the patient know, how to tell, when to tell, who to tell, should the family be involved, would that be advantageous or would that be detrimental, and so on. So I think a lot of clinicians face this question all the time, and especially also what is the cultural component to that, right? For example, in Hong Kong, that family is very important, and the role in making that decision is crucial, and it's not just an individual as a patient who makes all the decision without consulting the family, right? So that balance between the family and the individual is delicate. As we move to multiculturalism, not only in Asia, but in other countries as well, we see this also happening in South America, for example, also family-oriented. Europe, also Eastern Europe, and Africa, and so on. So these values of the patient, be they religious or cultural or based on the background, seems to be an important element for the patient to make a truly informed consent. And at the same time, a lot of doctors are at the beginning, unaware or not very familiar with these different systems of beliefs. But yet, at the same time, doctors are also changing. They're no longer just your homogeneous type of doctors, or they talk about American doctors. We're talking about just white Anglo-Saxon and so on. So this is also changing reality in the West as well. The doctors are becoming much more diverse, right? So all these elements allow us to reformulate this concept of autonomy to be much more complex. It has to do with capacity to choose, but also the ability to implement these choices. Okay, a person may not always be able to exercise one or both of these aspects. And once again, we see this shift between the West and non-Western cultures from the autonomous self, basing on individual right to self-determination, to a relational self, a self that is more embedded in the network of social relationships. And decisions are made also not excluding the family. So this is a saying from Brody and Quill. And so going back to this case that Dr. Edmund Hui proposed, what do you do? Should the doctor provide this prescription to the mother? Because this would be somewhat kind of lying to the patient, and the patient has the right to decide what is best for him. I use this case a lot in my classes, and actually, usually, even though the patients are, the students are from many diverse backgrounds, Europeans, non-Europeans, Asians, South Americans, and actually it's usually half and half. 50% would say that, yes, the doctor should give the mother a prescription so that she could continue, because this is for the best of the patient, right, with schizophrenia. The other half would say, no, this would be against his individual rights and his autonomy. So it's very interesting that the case is divisive in a sense that the patients, the students today, even in bioethics, are not decided about how does culture factor into this kind of decision. It's very interesting in this case because it's a real case. And the solution here is something that a lot of us may not have thought of. Basically, the doctor invited the mother, okay, to bring her son, okay, into this encounter. And in this encounter, mother confesses to the son that I'm giving you the medication in your soup. And in this encounter, the son agreed to take the medicine from the mother if it is put in the soup. So it was actually a very good solution because in the end, the patient agrees. And what's interesting about this is that the cultural element is very important because the doctor being Chinese, was able to have this sensitivity to understand, okay, informed consent is important, but also the cultural element, because the son, seeing that this is an expression of the mother's love for him in the soup, would not refuse the soup. So this dynamic, I think, is very, very interesting, especially in a place like Hong Kong. So once again, I'm ending this with the last slide. How do we actually implement that? And I think it's still a work in progress. We just need to continue to work on this and to realize that the traditional type of individualistic autonomy is insufficient in many cases. And we need to take into account all these newer nuances about the family, about relational autonomy, and then also ways of implementing that in the healthcare setting, either by patients group, by doctors, by social workers, and so forth. This is it. I think I did it within time, and hopefully you might have other questions.
Indeed, thank you so much, Father Joseph Tam. We will have questions towards the end of the webinar. Thank you so much for your very nice talk. I'll watch out for what I'm drinking tonight. And so we just had a discussion from the relational perspective. Next, we will have another presentation from a Buddhist perspective. I would like to welcome Professor Alan Zhang, who is Head and Director of Center for Applied Ethics and Associate Program Director of Master of Arts in Ethics and Public Affairs and Professor of Department of Religion and Philosophy from the Hong Kong Baptist University. And she's going to talk about informed consent from a Buddhist perspective. Alan, please.
Thank you, Chair. Let me pull out my slides here. So actually, I'm going to talk about informed consent process and the important 4 elements here, and then response, from multiculturalism and Buddhism. Okay, according to the UNESCO Declaration of Bioethics and Human Rights, an informed consent process requires 4 basic elements to be valid, namely voluntariness, disclosure, understanding, and capacity. So whatever one of these elements is missing, informed consent can be compromised. So in my presentation, I'll talk very quickly about informed consent. Is 4 elements in the whole process, and then I try to give a response from multiculturalism and Buddhism in particular. Of course, I have a bigger question behind that, and that is, can we bring an ancient Eastern tradition like Buddhism here into conversation of the contemporary debate? And if so, what's the purpose of doing that? Okay, let me go very quickly because I think I have too many slides here. Okay, first of all, voluntariness, which is closely associated with the protection of a person's autonomy. And then you see here, autonomy is a really big argument behind the informed consent. And voluntariness is usually seen as a choice being made from a person's so-called free will instead of a coercion by some external forces. The word autonomy, as we all know, is epistemologically from ancient Greek language with a compound of 2 words, auto, and also rule, which means autonomy has this connotation of self-rule or self-governance. Of course, in today's context, the word is using quite diverse meaning. It does not refer to a universal concept, but maybe with some other, meaning. So that's why we say autonomy itself is a very complex concept. And of course, and here 2 conditions are essential in terms of the concept of autonomy. First is liberty, and the second is agency. It follows that the idea of voluntariness implies that patients, as an autonomous individual, should be absent from any substantial control by others. So that's the issue about the non-coercion. And in addition, Beecher Childers also add the third condition, that is, an autonomous agent should have a complete understanding of his or her action. Therefore, voluntariness needs to meet the three conditions: liberty, agency, and understanding. And of course, the basic idea here is to respect a person's self-determination concerning his or her health or medical decision. Disclosure, the second element. Why must the physician or health provider disclose to patients, and what does it mean by permission to disclose? So disclosure means that the medical professionals is obliged or obligated to disclose a core set of information to the patient or subject regarding the treatment or research. So I'm not going to read the whole thing. So the idea that, is very important to offer the necessary information. Of course, according to the UDBHR documents, also indicated the whole idea here is based on two important principles, namely beneficence and also the principle of no harm. However, the questions of standards of disclosure or the need for so-called intentional or deliberate non-disclosure has by no means been answered without further qualification. For example, like when we talk about the clinical research, here Beecher Childers they speaks of so-called four conditions. First, it is intentional to obtain vital information, and secondly, no substantial risk is involved. Third, the subjects are informed that deception is part of the study. And fourth, the subjects give their consent to participate under these conditions. And this disclosure, of course, also followed by the idea of understanding, because without understanding, the so-called self-governance or self-determination just means nothing. So informed consent here emphasizes autonomous choice, as mentioned in idea of voluntariness. Informed consent in this context also means that there must a certain so-called substantial understandings are required, which means that which guarantee the notion of absence of control by others. Without understanding on the patient's part or the autonomous subject informed consent, or so information disclosure has no real meaning. However, the idea of substantial understanding is a tricky one, even if he or she is adequately informed, since it has a lot to do with the capacity for intention and for the intentional action and the capacity to grasping. So this, as we all know, highly professional information. Therefore, according to the UDBHR documents, it says that the appropriate, precise, and relevant information should be provided in a language and format that patients can fully understand. So here follow this idea, about capacity. Capacity is essential in terms of voluntariness and understanding, and also the notion of autonomy. So here we talk about patients' health literacy, the literacy level, whether this, he or she has ability to understand the consent. A patient needs to have the capacity of self-determination to reflect, decide, and consider when deciding to participate in a clinical trial or to receiving a medical treatment. So not only understand the documents, the content of consent, the person also supposed to has ability to reflect the whole thing and make the final decision. So the requirement for informed consent can be, but in the case, sometimes it can be exempt if the patient is, is incapable, or in the case of a minor, who cannot provide informed consent. So in this case, we talk about the idea of informed permission instead of informed consent. So here in summary, just quickly, so if we want the consent to be valid, it must be volunteered and informed, and the person consenting must understand the consent and have the capacity to make the decision. So now let me talk first, before I talk Buddhism, let me just have a general response from multiculturalism. Okay, whenever we deal with a very dynamic interaction between the universal principles and also different cultures, or we say different cultural perspectives or interreligious perspective, we need to acknowledge the complexity of cultural, societal, and religious differences. At the same time, we should also recognize the importance of generalization as a tool to understand the existing common ground or so-called overlapping consensus among different cultures, society, and religions. So as a universal principle, okay, so now we all take it as a universal principle, informed consent is generally acknowledged as an ethical ideal. So, but at the same time, different cultures may also interpret the four elements here, namely voluntariness, disclosure, understanding, and capacity differently. For example, in Japan, informed consent is understood as explanation and agreement, which may not be the same as the idea of, the original idea of informed consent, which is used in the Western culture. And also in the Chinese context, informed consent is translated as 知情同意, but in its application, both informed and consent entail more complex meanings other than what is indicated in a general principle. For example, in China, informed consent nowadays very often become a legal protection of the medical professionals rather than one for patients, thus creating an arbitrariness of the physician's relation to the patient. Moreover, there are also two questions to be considered. First, what we might call the same principle, okay, based on harm principle. The other is sick principle, based on the idea of self-determination, individual specific rights. So here, the implied culture, also we have to take into consideration the implied cultural clashes. For example, the individualism versus feminism or collectivism. So as a result, informed consent is sometimes employed in non-Western cultures context without justifying or even spelling out the definition. Okay, let me skip that part. Now I'm going to talk about a critical response from Buddhism. Okay, because as I mentioned, some underlying concept behind the informed consent dealing with the question about individualism, autonomy, self-determination, and even like human rights or human dignity. All these elements from the modern idea from the West. Okay, in Buddhism, respect for the dignity, autonomy of patients, here, of course, as a general principle, is a fundamental idea of ethical decision-making. However, such concepts as individual dignity, the autonomy, human rights are not derived directly from Buddhist doctrines. Then how do we understand informed consent from Buddhism? So, bioethics is something new. It's not like, in Buddhism, it's very old tradition, and also not just a religious tradition. It's also meant to deal with a lot of issues which are supposed to say non-secular. And also a lot of issues in modern bioethics also coming, the challenge of some modern ideas and also modern development of technology, which, of course, from Buddhist view at that time, it was non-issue. So here the question, how do we bring in a very ancient different traditions and say how to apply that into the contemporary bioethical or medical ethical context. So I mentioned that those terms are not, from Buddhism. And so in a sense that the Buddhist tradition has no language equivalent to say human dignity, human rights, it would have no problem accepting, of course, the same concept about human rights, especially when the fundamental rights to life is violated or threatened. In other words, human rights are necessary because they reflect certain moral standards of how humans should be treated and how a violation of such standards should be condemned. The right talk implied informed consent here serves the same purpose in that the key idea of informed consent is to protect the patient's interests, endorsed by the principle of beneficence and the principle of non-maleficence. That means Buddhism would accept the qualified notion of human rights as a protective mechanism. Nevertheless, Buddhism would be very cautious about using rights language, since the human rights suggests the informed consent are used as a means not only to protect individuals, but also to affirm a kind of what we might call moral individualism. Although people talk about here collective rights or the rights of the particular group or community, the idea of human rights, whatever positive or negative, is based on freestanding individuals and individual autonomy. Yet from the Buddhist viewpoint, they really challenge this notion of so-called self-standing individualism and also this absolute notion of individual autonomy. Because Buddhist has a more like holistic viewpoint, rather than this notion of that a person is essentially autonomistic. For example, as volunteerness is based on autonomy, it requires two conditions: liberty and freedom to choose, and individuals' capacity, and also including individual capacity for intentional action. But if we scrutinize those two conditions from Buddhist perspective, we'll find them somehow ambivalent. Autonomy means, as we just mentioned earlier, self-determination, self-governance, or choosing without controlling influence of others. However, the question is how the controlling influence of others be defined. According to the Buddhist doctrine of interdependent origination, absolute self-determination is impossible since self is causally produced by others, particularly in culture like China and Japan, where self cannot be fully defined without an adequate understanding of the family dynamic. In the case of informed consent, then, it is very often difficult for the physicians and the patients to determine if the patient's deferral of the decision is his or her own choice or the result of formative influences of the family. And also the patient's capacity for intentional action is also questionable. Volunteerness involved the idea of free will, which would be problematic for Buddhists, and the medical decision-making based entirely on patient-centered orientation would be problematic for Buddhists as well. Because autonomy at the core of the human agency in the Western philosophy is to recognize, this notion of a personal autonomy that enable a person to, to exercise this notion of self-governance. Yet in Buddhism, self can be understood in two ways: self in ultimate reality, which is self in conventional reality. From the perspective of ultimate reality, self is an illusion, and it's there's an impossibility due to the nature of impermanence. From the perspective of the conventional reality, self has no substance or self-nature due to the idea of dependent origination of all things. The Buddhist concept of anatman or non-self denies the notion of this unitary understanding of self, an idea of self-identification and self-sufficiency. In other words, Buddhism questioned the ontological, epistemological reality of the self. So here, I have to skip that part. The theoretical part is back to the self. The whole idea here is that Buddha would argue that self in self-identification and self-determination cannot be absolutely autonomic and autonomous. From a psychological perspective, an individual's self-consciousness is dependent on the psychological continua that form the momentary stages of the self. Okay, for example, in talking ownership, authority, and voice in autonomous agents, Paul Benson points out that very often autonomous preference or values are subject to direct normative constraints. For example, a patient's position in his or her family would have a strong influences, as I just mentioned earlier. And Buddhists would maintain that I exist is true only as a convention. So I don't know if I have time, concerning the patient's capacity for the intentional action as a free agent, let's not just talk about external influence by others, but how about internal influence when the agent is confronting a life and death situation? Can we expect patients to be always rational enough so that he or she can fully understand his or her intentions? This is why Buddhists recommend meditations, and the practice of meditation so maybe can be understood as a way of cultivating the mind for developing a capacity for so-called autonomy. But even that, they still say maybe that kind of autonomy is still limited. Because according to the Buddhist doctrine of interdependent origination, autonomy is always relational autonomy. In informed consent, the patient's autonomy cannot be separated from the physicians, families, members, or communities. Buddhists are also concerned with the patient's psychological maturity to handle the language used when disclosing information about the risk of a medical treatment. So my concluding remark is that informed consent is a complicated, just like Father Joseph talked about earlier. It's a very complicated issue and may have desirable and undesirable effects on the medical clinical practice. Nevertheless, it is better to have and take it into the consideration. It's better to have it, but at the same time, we need to take into the consideration of the cultural differences. So again, I also want to mention that there's a limitation, of course, and also the limits of the Buddhist part to fully response to the issue here, because bioethics is a cross-disciplinary subject not founded in the traditional Buddhist thought. So we need also be cautious not to impose the Western ethical framework on Buddhism simply for the sake of conversation. So that's the end of my talk. And also last one to mention is a really interesting movie made 3 years ago. It's called The Farewell, and the Chinese translation 别告诉他 here also dealing with the question about the some of the issues that we mentioned here, but the movie really is a great story. On the surface about the clashes between American culture and Chinese culture, but the whole idea also dealing with question about informed consent. Okay, that's it. Thank you very much.
Okay. Thank you so much, Ellen. Very, very interesting talk. Next, we will move from Buddhism to Confucian views about informed consent in a biomedical framework. So I welcome Professor Ruben Fan, who is Professor of Department of Public Policy of the City University of Hong Kong. Ruben, please.
Thanks, Chair. Let me share my screen. Like Ellen, I also contributed one chapter to the cross-cultural account book edited by Father Joseph Tam. Ellen contributed the Buddhist perspective. I contributed a Confucian view. As both Father Joseph and Ellen already mentioned, everyone knows that principle-informed consent nowadays has two basic requirements. One is providing information to the patient. Two is obtaining consent by doctor before obtaining consent from the patient before conducting any serious treatment on the patient. My paper, I'm a philosopher. Philosophers usually write very abstract and dry and boring things. So that may not be quite suitable for delivering this presentation. So I will also report research we did about 15 years ago. We discovered 3 different models of the practice of informed consent regarding, consent from whom, patient or family, or patient and family, supplying information to whom, the patient only, or family, or patient and family. We did the research in 3 cities, Beijing, Hong Kong, and Houston. In each city, we picked up 2 public hospitals to interview physicians, patients, and family members to find out how they practiced informed consent, and also how the doctors offered information. So one model is Houston's individualist model. Roughly, it's the competent adult patient is the usual decision maker and the presumed source of authority for medical decision making. More specifically, the doctors directly inform the patient, including very bad news, and the doctor should receive consent directly from the patient. If there is need, signature for serious diagnostic or treatment work, the signature should be offered by the patient, him or herself. Very much encourage patients to prepare advanced directives, in case I'm becoming incompetent, how the decision should be made, who should be the surrogate decision maker, that kind of things. A lot of patients do offer prepare advanced directives, and family members involved only with consent of the patient or by default. Then we found a quite different model in Beijing. We call it family model or familist model. Roughly, the family of the patient is the usual decision maker and the presumed source of authority for medical decision making. More specifically, for this time, and the doctors, if it's very bad news, cancer specifically, they would first inform the family, not the patient. And so the consent will be from the family. Usually there will be a family representative who also offers signature or things like that. People do not have interest in advanced directives. So even when the patient is competent, the families already assume a decision-making authority. After the patient becomes incompetent, the family just logically continuously to do it. So the patient is taken to be part of the family. And finally, we found a mixed model here in Hong Kong. Roughly, it's both competent adult patient and the family are taken to be the usual decision maker and the presumed source of authority for medical decision making. I assume these 3 models still operate nowadays, But maybe something changed a little bit in Hong Kong, and audiences can correct me. We picked up at that time 2 hospitals, Elizabeth and Guanghua Hospital. We found the physician usually inform both family and patient. They got the family and patient together to tell them this is very bad, cancer, which stage, what kind of treatment should be offered, and so on and so forth. So of course, by doing this, need not to ask the patient first, do you really want your family to be involved or not? The physician did not need to ask the patient, like in Houston. So they talking to the family without the need of obtaining approval of patient. They got consent from both patient and family. In many situations at time, they ask both the patient and family member, especially for senior patient. They call it a major signature, minor signature, something like that. So some patients here have interest in advanced directives. About justifying the individualist model, like in Houston, like in most Western regions, and scholars usually refer to 2 things. First is, of course, the right to individual autonomy or self-determination. And Alan and Father Joseph already talked about a very strong liberal deontological principle operating nowadays. And the second is more like a consequentialist consideration, namely to practice the individualist model would result in the best possible consequences because everyone pursues and knows one's best interests. So you better let everyone to decide for him or herself. It's this consequentialist justification is often challenged, not only by us cross-cultural scholars, also often by Western scholars. The issue is sometimes, at least, individuals, patients do not know their best interests or do not pursue their best interests, either out of ignorance or fear or confusion or whatever. And so this second justification, consequentialist consideration, is often backfire, cannot hold. Then the problems with the feminist model as they practiced in Beijing or other places of mainland China are 2, at least from my perspective. The first is, under that model, a lot of patients become very much inactive. They leave everything to family members to make decisions. These are often life and death decision making. It's quite burdensome. So it's a bit, sometimes I do feel it's a bit unfair for families to take so heavy, so much obligation all the time. The patient just sit there or lay down and say, I don't want to know everything. Just talk to my wife or talk to my husband, or talk to my son. I just don't want to do anything. I'm a sick patient. I need to be taken care of. That's not quite confusion, because confusion values, from my understanding, encourage one to take one's responsibility and to be virtuous and so on. The second problem is, of course, at least sometimes the family may not decide in the best interest of the patient for, various causes or factors involved. What about our mixed model in Hong Kong? I personally very much support this model. I think this model can be defended from a Confucian virtue ethics perspective. The only problem is we need to find out the proper way to handle disagreement between patient and family. Sometimes, patient and family hold disagreement. Then, of course, individualist model says, go ahead with the patient. He or she has the right or authority to make decisions. That's his life. That's his health. And that's would be the individualist decision. And families the decision on Beijing side would say, no, follow the family. Families not only take care of the patient, families usually pay for the patient. You have to. Anyway, but I think there might be more complicated, at least ethically. Ethically, it's more complicated for the medical doctors and even legislators to consider whether you want to go that all-sweeping way to say you always follow the patient or you always follow the family. I think there should be somewhere different, I guess. To sell my title, I said I promised to offer so-called Confucian perspective of informed consent. I guess I have to say a little bit about that. This tradition, Confucian culture, still very much influences people's life, at least in this part of the world, East Asia, including Hong Kong. That's clearly the culture carries with it a virtue-based and virtue-oriented moral system. In this culture, it takes the concept of the virtue rather than concept of individual rights or liberty or equality as the foundation of morality. And such virtues are still commonly practiced and talked about in reality, 仁义礼智信孝, or in English, humanity, appropriateness, propriety, wisdom, fidelity, filial piety, harmony, loyalty, and so on. But the culture also very much has the elements as the basic concern to protect legitimate individual interests. Therefore, from my perspective, although the Confucian culture in tradition never developed concept of individual rights, and it should logically and reasonably nowadays to develop and accept that concept, individual rights, because the effective way of protecting legitimate individual interests, as Confucian culture concerns about, is safeguarding a list of individual rights and basic liberties and equality. This list certainly includes a right to informed consent in society in general or in biomedical practice in particular. However, there must be a qualification, because this rights mechanism is developed after for the virtue-based, virtue-oriented Confucian culture. Such rights, as well they are exercised, should not be in conflict with the central requirements of the virtues. I just mentioned the 仁义礼智信 and so on. Such central requirements would include like caring for family members, keeping harmonious family relations, making shared family decisions, and these kind of typical Confucian values or the central requirements of the virtues from my understanding, and the practice of the rights, including right to informed consent, should be consistent with such virtue requirements. Then I would argue that if the Hong Kong mixed model is the model of informed consent supported by Confucian perspective for nowadays, then to settle the disagreement between the family and the patient, the physician should be virtuous physicians and should practice wisdom, rather than decide I always follow the patient's decision, or I always follow the family's decision. Well, it should be determined based on particular context, particular circumstances. Sometimes you go with the physician, the patient. Sometimes you go with the family to persuade the patient that the goal is to, really serve the best interests of the patient. Here, the good communication would be very, very important, and the good communication among the physician, patient, and family is crucially important. Discrimination is very harmful if people are familiar with practice, and sometimes discrimination destroys everything important. Thank you for your attention. These are some papers I have published about Confucian view of informed consent. You are welcome to offer your comments and critiques. Thanks.
Thank you so much, Professor Fan. You're absolutely right that the Hong Kong model does have its advantages as well as challenges. As a clinician, I can tell you that. So thank you so much for your wonderful talk. I think it's time for us to have a break, Kelvin.
That's right, Professor Leong. But I'm afraid we'll have to keep going in interest of time.
Right. Okay. Yeah.
Yes. I hope that's all right.
Can we have 2 minutes for a bathroom or something?
Okay, you have 2 minutes, and the clock starts now. Okay. Why don't we meet again? Regroup in 2 minutes. Thanks so much.
Right. So 120 seconds of toilet break, and then we'll come back in the second session. Thank you so much.
So welcome back, everybody, to the second panel of this webinar. So some of you may recall the Charlie Gard matter in the UK. Of course, that was when parents of a terminally ill child cannot agree on a proposed intervention with the medical team in the UK. And of course, that dispute led to the involvement of the Vatican, the then US President Donald Trump. And of course, it got brought before the UK Supreme Court. The matter was then considered. And of course, the ruling was in favor of what the clinicians decided ultimately in the hospital. And Imogen, of course, has very helpfully brought together a group of scholars to consider the matter and to revisit this point of perhaps the relationship between law, which is quite prescriptive in terms of its requirements on informed consent, and broader considerations in culture and religion, and of course, different social settings. And in her edited monograph, which myself and a colleague, Professor Sharon Kaur from the University of Malaya, had the great privilege of contributing a chapter to, we considered the situation in Singapore and Malaysia. And my colleague here in Hong Kong, Professor Daisy Tiong, who wrote about the Hong Kong situation, they were quite different from the UK situation because we did not find ready recourse to the courts. So that difference cannot be explained as a matter of law. But I'm not sure that we came to a very clear conclusion in terms of whether the reason was because of culture or religion or perhaps some other social practices. So it would be wonderful to hear the thoughts of Professor Gu. So with this, my great privilege to invite now a great friend of our center in Hong Kong. Imogen herself has been to Hong Kong and hopefully will be back with us in the not too distant future. So with this, it's over to Professor Imogen Gu, who is Professor of Medical Law at the University of Oxford. Professor Gu.
Thanks so much for that incredibly kind introduction, Calvin. It is really good, albeit only virtually, to be back in Hong Kong. I really think your centre is fantastic, and I'm really glad to be involved again with the work that you're doing. I think you've given a fantastic summary of what the book did. And so what I thought I'd do today is try to distill some of the things that we learned from the comparative analysis and try to tease out some of the things that we could see were similar or different, and what that says about what we all ought to be doing. Because the way we thought about the book was essentially, what could we all learn from looking at what other cultures do? So the way I'm going to do this is I'm going to talk to you briefly about the English background to these cases, but very quickly. And then I'm going to work through 4 areas that I can discern from, that we discerned as themes from what we found in the book. And I'll tell you a bit about how we created the book as well. So let me just share my screen. I'll put up my slides. There we go. Can you all see that?
All good. Thanks so much.
Okay. So the legal situation in England, which was where I was coming from when we started the book, putting it in a very small nutshell, essentially it's very consent focused. So for children, it is about if they're competent, they give consent. But by and large, the cases we're talking about are cases of very young children who are unwell and can't give consent. So the way it works in the UK, in England at least, and Wales, is that the parents give consent on their behalf. They're regarded as non-capacitous. Consent has to be properly informed, and we think of that in terms now since Montgomery for adults as being what would a reasonable patient want to know, and what would the individual patient themselves want to know, so objective and subjective. But we have a therapeutic exemption where doctors can withhold information, but only if they think it's going to cause the patient serious harm to have that information. And harm can't include not having the treatment. So you can't withhold information simply to make sure someone goes and does the treatment that you think you ought to do. So we're very much at that end of the spectrum, and I think quite distinct from some other jurisdictions' approaches in terms of really giving people information. It's quite difficult to avoid being given information here because the whole focus is on making sure people are given everything. You can refuse treatment, and parents can refuse treatment on their children's behalf. They can also consent on their behalf. So what we see with these cases is these conflicts about those decisions. It's also important to understand that legally in this country, you can't compel medical professionals to give care or treatment that they don't think is in the patient's best interest. The medical professionals very much know that they can resist pressure. In reality, they often acquiesce for reasons to do with the impact on the parents and the families and the children and so on. But legally, they can't be compelled. And we have a very clear pathway for what happens when there is a conflict between the parents and the medical professionals, which is that they can go to court and get a declaration of what is in the patient's best interests. So that's the concept that we deploy, is what is best for this particular patient. And I'll draw some comparisons with other jurisdictions shortly about that. When the court is invoked, so when it, and there's a range of pathways via the Children Act or via its inherent jurisdiction, it's important to understand what the court thinks it is doing, which I think is quite different from other jurisdictions. And it centres the child. So it regards the child as a vulnerable individual who can't speak for themselves and whose welfare needs to be protected. So for over 100 years, it's been very clear that the dominant thing the court has to consider is the child's welfare. We see this in Re McGrath from 1893. It's reiterated again in 1997 in Re T. It's very clear that it's about the child. And it is not about other people around the child. So in quite strong contrast to other jurisdictions, they don't take this holistic perspective, but rather they look to see only what is good for the child, to the exclusion of everybody else. There are one or two decisions where they stray from this slightly, but even then they frame it as, it will be good for the child if their parent is well, or it will be good for the child if they donate tissue to their sibling, because then their parent will have 2 well children, and that will be better for this individual child. So they still pull it all the way back, always back around to the individual child's best interests. When they think about best interests, they think about it from the perspective of the child. So they try to put themselves in that particular child, that subjective child's place. And they're very clear that best interests goes beyond just what is medically indicated, but take account of emotional dimensions, all welfare dimensions. And so that is one context in which they will bring in religious factors, religious dimensions. And we see it in the decision about 𝐷𝐸 𝐸𝐸. They're very clear that they were pulling in the religious and cultural aspects of her family life and her culture were part of how they made a decision for her in terms of sustaining her life and not withdrawing care. But they take the perspective that they are balancing these things. They make essentially a balance sheet and they weigh things up on either side, which has been criticized as a way to think about it, but that's the approach that they take. What I think is also important to see, and this is another thing where there is a contrast between the way the English system approaches things, and also probably is quite similar to Australia and to the United States, obviously because they have related legal systems, is that parents have rights, but these are contingent rights. So Lord Scarman says in Gillick, it's clear that parents have rights and duties about their children's medical care and the decisions that can be made about them. But then it's made very clear in Re-A that in fact, these rights should be better framed as responsibilities and that they're only allowed to exercise them in the child's best interests. So again, this is a contrast, I think, that parents here, when they make a decision, are meant to be making a decision with the child in question's interests as paramount. They're explicitly being directed to think about the individual child, not to think about the broader family. So that's a really strong contrast that they are. And if they don't do that, if they aren't making a decision that is best for the individual child, that is a ground effectively on which the court can be requested to intervene and make a declaration for that child. So essentially, not only parents' rights subordinated to the child's welfare considerations, but all of the other family members that the parent might want to consider are not part of that decision-making process quite explicitly. Now, the cases that we've had recently, Yates, Gard, Evans, and Rakib, these are all cases where there has been a conflict between the parents and the doctors, and relationship has broken down in each of those cases, and the medics have gone to court to say, can we withdraw care? In each of them as well, the particular issue is, could the child be removed to another jurisdiction? And just quickly, the big issues that came out of them that we've been facing are this question of, can you remove a child elsewhere? And also how to think about best interests. And the upshot here is, a child could be removed to another jurisdiction, but only if it's in their best interests. So that's what happened in Rakib. But if in fact it's going to be harming or not in the child's best interest to be removed, the courts have made it very clear that they will issue injunctions to prevent that from happening. So they see that as within the remit of their best interest jurisdiction to prevent children being moved. In terms of best interests, the things that have come out of this are, it's possible to have experimental treatment, that's fine, as long as it is of benefit and it's not harming, and that ongoing life-sustaining care can be lawfully withdrawn, even though the parents wanted to continue, unless post-Rakib, it seems that it's not harming to the child, and also that there's a responsible medical team who'll take over the care. So the big thing in Rakib was that the alternative treating team were regarded as responsible medical professionals, and so her care could be given to them. So that's where we're at. So the reason that we came to make the collection was the particular thing we noticed was that we have a lot of conflicts in England and Wales. We're having lots of these cases. And the thing that kicked it off for us was to think, it doesn't seem like other countries are having such a problem. What is it that is happening here that's precipitating such public dispute? And that's what what sort of made us wonder. And then the way we proceeded on this was to try to find a way to represent as many jurisdictions as we could. We had, I think, 26 countries represented from 5 continents. We reached out to people wherever we could find them through all sorts of ways to make sure it was really broad. And we did it as well because people kept saying to us things like, well, it would have been different if this case had happened in the United States. And a really big example was the 𝐸𝐸𝐸 case, a girl who'd been kept alive for a very long time in a way that doctors here would have refused to do. And the argument there was that the culture in the United States and the insurance situation meant that different decisions were made. So there's 4 things that came out of our collection, I think, that I'm going to talk about, that explain why the situation might be different. But the primary question initially was why that was happening, and then what the differences were. So one of the things that we did notice when we spoke to people was that actually lots of countries don't really even have a legal avenue to take these conflicts to court. So that's like a really important starting point. So say in Sweden, Pernilla Levina told us that in fact they just don't really have a facility for medics to request intervention at all, that doctors just don't have an opportunity to petition for the court to do anything at all. Thailand, similarly, there just wasn't this pathway available. So that's one threshold question. Is there even a legal mechanism? And sometimes there isn't. The second that we thought about was, are there different thresholds when courts become involved? And the argument was, yes, there were. So in England and Wales, our threshold is welfare, it's best interest. So as soon as the child's welfare is affected or adversely affected, then the court can be asked to intervene. That's true in quite a few other jurisdictions, Belgium, Spain, and as I understand it, Hong Kong. Other countries, however, other jurisdictions take a different approach. And this was an approach that was argued for in the 𝐻𝐸𝐸 case and rejected, which is the idea of a harm threshold. That in fact, in that context, you would say that the parents' decisions hold sway unless they are likely to cause the child harm of some kind. And that's been one of the debates in this country about whether we should move to a harm threshold. So say in Chile, the threshold is a risk of serious harm or death. Mexican Supreme Court has reflected this. Swiss law says that parents' wishes hold sway unless they pose serious endangerment. I think Calvin and Sharon in their chapter suggested that Singapore effectively in practice has a harm threshold, and Australia appears to have one as well. So it's not an unusual approach. But what emerged from the rest of our explorations was that this wasn't the whole of the story, though. So sometimes there'll be jurisdictions where, yes, the guardians are able to act in a particular way, but in practice, hospitals will follow what the parents want. So say Ding Chunyan told us about China and that their guardians can have to exercise their responsibilities in line with the child's best interest. But in reality, hospitals will very often yield to what the guardians want, even if they might have said that in this particular child, it's not in this particular child's best interest. And as I'll explain later, as you probably understand, this is because decisions being made in China are much more likely to be made with the entire family in mind, as opposed to the individual child. So that's why they respect them, because that is culturally the way such decisions are approached. I am mindful of the time, and so I shall be swift as I can be. The other thing that we found was that different countries, different jurisdictions allow different people to have the dominant voice. So in some jurisdictions like Peru and Thailand and Norway, parents very much had the dominant voice. So their voice was simply the one that would be the trump. Whereas, say, in Malaysia and Sweden, it emerged that very often parents would defer to medics. So say in Sweden, parents just don't really argue with doctors, even if they don't agree. They still just allow the doctors to be the one who says, well, this is what is best in this situation. And this stood in quite strong contrast with Southeast Asian jurisdictions and China, where it's quite clear that decisions were being made by families as opposed to parents for individual children. And this, as I understand it, is deriving from this much less individualistic worldview and rather a familist worldview, where it's expected, in fact, that the guardian will make a decision about the care, taking account of all of the family's needs, and that as an impact of this, that doctors would defer to that. So that's the third thing that came out of it. The fourth thing that came out of our analysis that was really interesting as well is that different countries take different approaches to alternative dispute resolution. This has different impacts. So in some countries, it's expected that they will go to mediation, that in fact, they deal with conflict quite head on, or they have ethics committees which have binding authority, which can address situations, which is also why these cases don't go to court, because in fact they're dealt with within institutions. Now there's good things and bad things about that, but that was a real difference across cultures, is that some are very much focused on a mediated process that creates an outcome which makes everybody happy, whereas others, say England, where we don't have that, but we might be moving towards it, are much more inclined to go to court, have a dispute, and then have one voice decide what is right in this case, which is quite a different approach to these sort of situations. I think the final dimension to this, and then I'll wind up, is there will also emerge quite a distinct approach from some of the African jurisdictions. So distinct again, where we saw individualistic contexts like England, familist contexts elsewhere. A number of the African commentators commented that actually they took an entirely communitarian approach. So not so much mediation at ethics committees, not so much just a familial-based decision-making, but an entire community process. So both contributors from African countries noted their communitarian approach, which was also coupled with the desire to resolve conflicts without going to court, but that actually they had framed these decisions really quite differently, that the community took responsibility and that these things were thought about via a network of communal relationships, and this ethic of communal relationships really thought about not individuals so much as rather individuals within communities, and that this would motivate members to seek the good of the community, and that's how the decisions might be negotiated. So what do I think we can take from all of this? I think one thing that you can take that's really important to take from this is that there is capacity, I think, as we become more multicultural, to find ways in which this can be accommodated. I think one of the things that some systems do well is to account for other cultures' views. Others do less well at this, depending on the way in which the situation is framed and managed, is part of it. But what I really noticed, I think what we really drew a conclusion about here, was that what we need is a way to accommodate value differences. So it's very clear from the cases that we've seen in England that people with different cultural backgrounds come to these situations with really different cultural positions, different perspectives on value. What is valuable? Is a longer life valuable? Is a life free of pain valuable? The extent to which one person's interests ought to take precedence over other people's. And at least what I argue in our work here that we need here is a capacity to accommodate that. And we've seen it in 𝐂𝐸 that I think a very good job was done in that decision. We see in other decisions where in fact very little is done to accommodate the fact that people might have different value perspectives. All right, thanks very much. I'm going to leave it there, but do feel free to ask me questions. I'm trying very hard, Calvin, to not go too much over time for you and help you. But do please ask me questions at the end.
That's brilliant. Thank you so much, Professor Gould. So wonderful overview there. So lots of insights. Well, if you're a student at HKU, you're welcome to look at the work. It's freely available, e-copy of this from our library. For those who are not, you're welcome to look this up. And of course, in relation to the earlier edited volume, the one that's edited by Father Joseph Tam. So that volume is freely available online. So with this, thank you so much, Imogen. I do think that there are questions for you already in the chat, so please do have a look. We now move on to two practitioners to draw in the practicalities and to invite their views on these two works. So we will begin with Miss Jinyi Lin. Very happy to see Jinyi. She graduated top of our class, the LLM program, and she has lots of experience as a medical social worker in Singapore. So that's over to you, Jinyi.
So thank you, Kelvin. Sorry, let me just try and share a slide. Can you guys see my slide? Okay.
Yep, we can. Thank you.
Okay. So thank you for having me here. So I'm a social worker in Tan Tock Seng Hospital. Yeah, in the background, you can see that's the picture of my hospital. I've been in practice for about 10 years in a hospital setting and another 3 years in the community. When I was in the community, I was working with people with severe intellectual disability. So I guess a lot, and currently now I'm working with patients with neurological conditions. So I guess a lot of the people I deal with have no mental capacity and no legal capacity as well. So I'll start with a summary of the two monographs, the two books that were very insightful for me, and also maybe a personal sharing about how I think it implicates our practice on the ground. So we already know from the previous speakers that, in the previous panel that respect for autonomy is, of course, is one's right to make decisions for themselves. And we already know that our traditional view of autonomy is too individualistic and it doesn't capture the breadth of human interest and agency. Because after all, we are social and relational beings. We are embedded in complex networks of relationships with people whose values we may adopt and whose views we will respect. And I think earlier on, Professor Allen was sharing about the components of autonomy. And I think a lot of times in healthcare, patient autonomy is not just about the capacity to choose, which involves competence and authenticity, but it's also one's ability to implement that choice. So for example, you may decide that, okay, I want to initiate on dialysis. I need to go to the dialysis center 3 times a week, but there's nobody who can bring me to the center. So how am I going to do it? How am I going to get there? Is my family support in? Or, patients who are on ventilator and they want to go home instead of going to a nursing home, can the family support that kind of care? So I think a lot of times there are limits to even exercising our own autonomy. So ultimately, a lot of times, healthcare-related decisions are not wholly individual, but often a family matter based on mutual reciprocal ethic of care. And it does involve family and support social support of the patient. And I think this is even more pertinent when we come to medical decisions for children, because they are wholly dependent on their parents for their care. I think we've already gone through this in terms of how it is important that this approach towards informed consent is not just one that meets certain procedural requirement, but it's really a process of communication and having good patient-physician relationship. And even though the individual patient is the one who is responsible to give the consent, the relevancy of relational autonomy also means that the patient's legitimacy of his decision may also not just belong to himself, but to the community. I think we have learned this from Professor Wei Ping's sharing about different models of decision making, whether it involves more of the family. And oftentimes we also see patients who want to hand over the decision making to the physician or even the family, and there's some level of delegating. So does that also entail exercising their autonomy? And also the relevant values that are pertinent to different cultures and religion of the patient that I think is important to be cognizant of. And I think this will also come into play when we come to being surrogate decision makers for patients without capacity. Okay, so I'll come to this part about how important is it to be aware of these social, cultural, legal differences in different jurisdictions. And I think Professor Imogen was sharing about the differences in parental authority and role. So for example, in certain cultures like Thailand, parents may take like a central role. In places like China, where the family, has a lot of authority over medical decisions. I think in a lot of our Asian culture as well, even though we know that, how we interpret best interest, and even though we know that we're supposed to act in the best, the decisions are supposed to be in the best interest of patient, there's this question about to what extent do we relent to the choices of family members. I think a lot of times it also depends on our medical culture. I think we are quite a conflict avoidant culture. We do have quite a conflict avoidant culture, I believe, in Hong Kong and as well as in Singapore, where we do want to try to come to consensus. Yeah, and a lot of times we do want to, build relationship and trust. And I think that is the crux of the paper as well, in terms of, it's not just about turning. Of course, there is a role of court. There is a role. There is a place for the court to intervene, and there is a place for the state to come in to take action where certain, perhaps, threshold for judicial or state intervention is met. But how can we try to resolve dispute via alternative mechanisms first? So it's really this question about how interests and rights of the person is balanced with the responsibilities and authority of the parents or the family. And I think we have to be very aware that whatever healthcare related decisions that we are making, the actual care of the person in the long run actually really depends on the parents and the family. And I think this is where this quote from Ray T is very relevant, that in the last analysis, the best interest of the child will always include these expectations that the difficult decisions affecting the length and the quality of life of the person will be taken care of by the parent to whom his care has been trusted by nature. So I think some reflections that I had pertaining to the book pertaining to medical decision making for young persons on behalf of young children is I do think that there are many similarities with the position in relation to adults without mental capacity as well, and how the authority of the family or the surrogate decision makers are involved. When, for example, in Hong Kong, you have guardians acting on behalf of patients without capacity, where they can make personal decisions for the patient. In Singapore and UK, we have donies, where a person, when mentally competent, can appoint someone to be their surrogate decision maker in the event that they lose mental capacity. And of course, if a person didn't make that appointment in advance and they have lost capacity, then the family can apply to the court to be a deputy. That would be similar to guardianship. But there are nuanced differences between the authority of the parent versus the authority of a surrogate decision maker. So this is my perspective on the ground. So a lot of times these surrogate decision makers, they are appointed, for example, if they are appointed by the court, they are required and mandated or required by law to act in the best interests of the patient. So I think a lot of times on the ground, as social workers, if we do know that someone who is a guardian or who is a deputy is not acting in the best interests of the patient, even though perhaps significant harm may not have been caused to the patient yet. So for example, they didn't use the money in ways that they should have, they didn't buy, they didn't bring the patient for treatment or, whatever smaller matters, but have not led to significant harm. We may have the authority to already raise it up to the relevant ministries for their action, for example. So whereas in terms of where parents are concerned, I think we are less likely to raise, to the ministry of, whichever ministry that's in charge, if the parent didn't do some of these things, because I think then there is this question about zone of parental discretion, whether, when it comes to parental authority, whether there is a higher threshold for harm before certain state intervention comes in. So, and I think likewise for surrogate decision maker, a lot of times we have very specific powers rather than broad powers, whereas parents are sort of have the authority to make decisions in every aspect of the child's life. And of course, for surrogate decision makers, the powers can be revoked if they are found not to be acting in the best interest of the person or the child, whereas of course parents, you can't revoke their powers and their authority. So I think key questions to ask, which I think which was also reflected in the book as well in the second chapter. So what are we deciding on? Who should have the authority to make that decision? How to decide? How to resolve and minimize disputes? including developing approaches that that focus on building trust and communication and being culturally sensitive. So I wanted to summarize my key takeaways in a table, which I think some of us, if we are practitioners, we may find it useful. So I guess what are we deciding on? Are we deciding on medical treatment or care-related decision? Of course, when it comes to care-related decisions, we may accord a lot more latitude to the family or the parents, for example, because ultimately the long-term care of the person depends on the family. Who is deciding? And I think a key question to ask ourselves is, does patient have mental capacity to decide? If not, so if the patient has no mental capacity to decide, did he or she have any advanced directives or have made any advanced decisions pertaining to his treatment or care? Otherwise, then the next question is, who is the appropriate surrogate decision maker to make that decision for him? Of course, bearing in mind what is the primary unit of decision making in our culture. So for some places, it may be very individualistic, whereas for some, it may be family, whereas for some, it may even be the community. And this question about how to decide, patients with decision-making capacity, of course, patient autonomy takes precedence, but a patient cannot demand treatment from a doctor that doctor thinks is not in his medical best interest. So there are limits to that autonomy. Of course, and also the patient can choose to involve his family in the decision-making, and I think that's very well his rights. For patients without capacity, then the way to decide is, we follow the best interest principle, at least in Hong Kong, UK, and Singapore in our jurisdiction. But there's also a lot of differences in the way we interpret best interest, which I think has been covered earlier on. So how do we minimize dispute or try and resolve dispute? That's where I think relational autonomy and the importance of cultural competence come into play, being sensitive to the different values that exist, especially when you have patients coming from different countries, because Hong Kong is a very cosmopolitan city. You have expats from everywhere, and I think it's sometimes also to bear in mind what kind of cultural values or religion that they may have, and the importance of communication. And I think this is where perhaps the role of a social worker is pertinent, because a lot of times if I do tell my medical colleagues, if they do foresee that there may be differences, usually you can tell at the start of your relationship with the family where, there's a lot of disagreement at the beginning already. It's good to rope in the social worker early, so we have a longer runway to work with the family and the patient to kind of understand what are their values and, their goals as well for the patient. And that's how we can build that relationship and that trust. And generally, we do want to really come to consensus rather than, resulting in an acrimonious outcome where we have to fight out in court or, where the state has come in. And I think in a lot of our societies also, because the reason why relationship building is very pertinent is because if you work in a public healthcare system, the family members are going to be your patients as well. So ultimately, I think it's that trust building that is important. And then also having alternative mechanisms for dispute resolution via a clinical ethics committee, or even the offer of getting a second opinion or transfer of care. I think so. It's like for one of my case where there was this very elderly patient. She came in, she had multiple comorbidities, and she came in with a massive stroke, and the family was devastated. There was a lot of discussion about whether to initiate dialysis, but she was already bedbound. She was dependent on a ventilator. She required oxygen concentrator. So this option of initiation on dialysis is really not recommended by the medical team, but the family found it very hard to accept. So of course, then we got in the clinical ethics board as an independent party to, mediate between the healthcare team and the primary team and the family to discuss what is important to the family as well as what is the medical perspective. And then also we offered them the option of going to seek second opinion or to transfer the care of the elderly to another private hospital. So we give them time. We offered to provide whatever reports they need. that they need. And of course, I think after they went to consult other specialists and they realized that it's really not recommended, and I think they came to terms with it, and of course they stayed with us, and eventually they opted for comfort care and the patient passed away peacefully. So I think there are many times, I think with the social worker support, with clinical ethics board offer for transfer of care, I think it can really help to reduce the chances of it, going to the court eventually. And then of course, there will be situations where disputes cannot be resolved. So this question about whether there are legal or ethical frameworks that permit state action, or that at least guide the need for judicial intervention. So for example, in the context of Singapore, we have the Vulnerable Adults Act, where I think it's similar to the Care Act in the UK. Do correct me if I'm wrong. So whereby if let's say there's a certain patient cannot, or the family cannot manage their care, and even of course we can give our opinions and our recommendation about what is in patient's best interest, and if patient is at certain risk of perhaps neglect at home, and then that's where we may be able to step in, or perhaps if because of the refusal for treatment, you can result in a high risk of harm to the patient, then that's where I think we can flag up to the state under the act to investigate, or to actually perhaps even get an order to require the patient to seek treatment. But I think a lot of times where the state does intervene, I do submit that there is usually a significant harm, there's significant risk of harm that may be at risk. Therefore, they would be more likely to intervene. So that's the end of my sharing. Do feel free to ask me questions. Yeah, thank you very much. And I'm very thankful for the opportunity.
That's brilliant. Thank you so much, Jinyi. Well, some interesting points there to consider, in particular, your insight as to relationship building, and of course, in response to Andrew's comment in the chat. We tend not to have lawyers involved at the start, so perhaps the way forward will be to bring in the social workers early on, isn't it? But again, I suspect that that's not going to be very different in the UK. So we continue to press on in exploring differences. We have our final speaker now, and someone with immense experience as a geriatrician, and someone who I've learned a lot from, particularly in the context of Hong Kong. He's Dr. Derek Au, Director of the Center for Bioethics at CUHK. So over to you, Dr. Au, you have the last word.
Thank you. Let me put up my PowerPoint. Okay, I'm going to use the time to touch on a few areas drawing from some papers which are quite aligned to my thinking on this point, on this subject. Although, as Kelvin mentioned, my background in early career is from geriatrics, really my thoughts on the issues of informed consent and relational autonomy probably is more related to my involvement in my hospital authority years, working on guidelines related to end of life. And these are some of the guidelines which I have been involved in drawing up for frontline clinicians. The framework of those guidelines would be quite aligned with the framework in Singapore, for instance, that we consider the importance of the autonomy and patient's best interest for competent patients focuses on informed decision. And there are actually written in guidelines that clinicians should strive towards consensus building with family as far as possible. And underlying the framework is what we call the shared decision making model. For MIP, I won't cover that too much in my talk, but that's the principles and approach being done in Hong Kong related to end of care issues. Now, as I said, I'm going to draw on from a number of papers, and I intentionally pick papers which are more commonly read or included in the healthcare field, and that is either from journals in clinical ethics, law, or some related topics, journals rather than from philosophy journals. This paper covers the talk on the issue of how or can we move beyond individualism. Okay, so upfront we can say that let us accept that individualistic understanding of autonomy, which as we practice here in Hong Kong, to a large extent, are useful in several ways. Okay, it helps to ease burdens from healthcare professionals in a number of ways. That it is aligned with legal principles and precedent cases. It is slightly, in some ways, slightly protective if you perform according to the approach, then it's unlikely or less likely to get into negligence issues. And it's less paternalistic, as some of the speakers mentioned, it counteracts the more older tradition of paternalistic decision-making by physicians, and yet it still allows physicians to control and manage the flow of information. So it seems to largely work in practice, okay? But let it also be accepted that, as some of the many of the speakers pointed out tonight, that individualistic autonomy has its problem or limitations. It conceives patients as independent, self-determining, and rational in making strategic choices in medical care, which is quite ideal, but not always the case in actual patient care, when patients can be quite emotional, quite vulnerable, quite confused sometimes from the illness. So this is a bit ideal in concept, but less so in practice. The individualistic autonomy does not actually accommodate the fact that patients, people are rarely fully independent individuals. And again, that has been covered by some of the earlier speakers. But the authors in this paper pointed out also that there's a gap between such theoretical challenges and the impact on practice. That is to say that even though there are many nuanced theoretical contributions that has challenged and successfully challenged such individualistic conception of autonomy and try to formulate alternative approaches, they actually have little impact on the actual clinical practice and research. So there's a gap between the theoretical challenge and the actual ability to make impact on practice. So what exactly constitutes a relational autonomy response? We talk about how it's desirable, how it would be a good thing to have relational autonomy being considered in clinical practice, but how does that actually work in practice? It seems that one approach is to say that, oh, physicians should pay more attention to and be more reflective on the patient's social position and various things as a kind of good practice. Okay, so this is perhaps a soft way of understanding what we do with the idea of relational autonomy in clinical practice, that is to make it a part of good practice. Or should we take a stronger position to say that this should really be normative, i.e. that relational autonomy should be really inscribed into ethical guidelines and practice? Is it possible? And if we try to do this, what are we going to make of the multitude of relational accounts of autonomy? Even tonight, we have heard Buddhist accounts, Confucian accounts, and other cultural perspectives. How are we going to, it seems to be impossible to entertain all the different accounts into actually a coherent sort of clinical practice. The second paper that I'm like to draw on is actually a literature review on the multitude of accounts of relational autonomy as used in end-of-life care. Now, this is specifically for end-of-life care. And some conclusions are drawn. the literature tends to be a reaction against individualistic autonomy rather than as a positive concept. So it's very well that we say individualistic autonomy is inadequate in some aspects, and to put up the alternative values perspective or philosophy. But this is still a reaction to the individualistic autonomy account rather than a positive concept that can be used in practice. And it's such a rich and complex philosophical sources that it's difficult to imagine how finite conditions can make use of it. So the author ended up saying that dialogical developments in decision making in end of life is much needed. That is, we would need dialogue between such perspective, modulative perspective, with clinical perspective to see if we can come together to make use of the rich thinking or discussions in the literature. One paper tries to put up relational, when considering relational autonomy, is to try to use shared decision making as a bridge. As I said, in Hong Kong, when we drew up the guidelines for end-of-life guidelines in Hong Kong, we do incorporate shared decision making model. And this model strikes a balance between putting all the decision responsibility on the patient alone after providing information, and what the physician considers to be of best interest to the patient, to have a chance for the two to come together to talk about options, discuss and hopefully analyze options, taking into account of the patient's values, and try to come up with a shared decision that would be good for the patient and also respecting the patient's decision. But even when we bring in the shared decision making approach, it's still necessary to make a distinction between shared decision between patient and the physician versus shared decision with the family, which is a different level of matter. And in practice, shared decision making model also has its limitations. That is, sometimes it's difficult to address confidentiality issues. It requires more time and more training for staff to consistently apply the shared decision model. And families can sometimes be emotional. And other authors have actually cautioned against dysfunctional families. So using the SDM for family members to be part of the decision-making process in informed consent is still difficult. And bear in mind that we are all still just talking about end-of-life decision. So as early as 2006, advocates have been put forward to say, oh, if SDM is such a good thing, we should make it standard practice for informed consent, not just end-of-life care. And this paper, I won't, for lack of time, I won't get into the detail. But in short, the authors eventually had to admit that this is a huge task. It's difficult to imagine putting SDM approach to all kinds of informed consent processes in healthcare. And you would perhaps need decision aids, you would need people to help the clinicians to share the workload to actually put into practice. So is this a non-starter? I was going to draw on Tom Walker's talk at our center a few years back on the thin and thick notion of autonomy, but I see that some of the speakers has already covered this, so I'll skip this few slides. Interestingly, this is, I think, my final slide. Interestingly, I think actually in practice, a solution or a kind of solution has already been proposed as early as 2005 in a really little notice paper talking about beyond autonomy. And the approach is simply to suggest that we could diversify decision-making approaches according to the patients. This has subsequently actually been adopted in many clinical settings. That is, we assess whether the patients wish to make the decision alone or whether to make joint decisions with some trusted persons in the family, or whether want to defer more to the physicians. So in practice, clinicians will be trained to assess the patient's wish to customize the discussion process to come to the final decision. And that would be, I think, as far as I can see, what we can do in the clinical practice in the front line. And even this, I think, is still in some slightly ideal situation with enough time and ability and training of the clinicians to put into practice. So in summary, I have made an attempt to take the question or the issue to a lower level, closer to the bedside, to make the case that even though the discussion of the multiculturalism and respect for diversity is really rich, there's a huge gap between that and clinical practice, and we need certainly more dialogue like tonight to see how we can benefit from the rich literature on this subject. So thank you very much. That would be the end of my talk.
Thank you so much, Dr. Au. Also very insightful. And well, I myself have got a number of questions for the speakers, but I shall not hog the forum. I'm not sure whether the panel, no, the participants are able to voice their questions directly. I suspect that that participants should be able to do so. In the interest of time, I think we can only have a few questions. My suggestion, if Professor Gilberto Leong is agreeable, will be for us to collect a few questions and then have all the panel speakers share their thoughts on these questions. So I was wondering whether I could invite Dr. Andrew Bird, who has shared many of his thoughts in the chat forum, to perhaps very succinctly, if that's possible, present your question or comments for all of our panel speakers. And I'd also like to invite Professor Albert Lee to do the same. Thank you so much, Albert, for the question. You may like to share that directly with our panel speakers.
Kevin, I think it may be easier for the moderator for you to simply read out the question.
Oh, okay. Yeah, thank you.
Yeah, and let the speaker do. I think that would save some time.
Right. Okay. Yeah. Thank you. So, well, there are many comments from Andrew. So, I'm afraid I will not do you justice, or your comments for that matter. But let me just ask this to all of the speakers. How do you see the law as being involved? Obviously, within the law, certain values are being privileged. But then we see that in some of these other systems, whether we're talking about religion or we're talking about culture, or otherwise, for that matter, social settings. So, so given this, do you see these various values as essentially competing? Can they, in fact, coexist? Can the law allow these other values to coexist when the law is arguably the only system that is backed by coercive force, potentially? So, well, there are some exceptions, of course. If we're thinking about the Islamic system, then obviously they do have the Islamic law arrangements. So I'm interested to hear your thoughts in terms of how you see the law is linking up to these other systems, and where you find or how you weigh up these various value systems. And ultimately, as just to pick up on the point that Dr. Au has mentioned, is there really such, or rather I should rephrase that to ask if shared decision making is at all practicable when we are to bring in, for example, the force of the law. So so that's a comment or a question that I have for all of the presenters. I wonder if Professor Leong would have any points to add. Gilberto, you're muted.
I think we should let the panel speak first.
Okay, yeah, thank you. I did get a message from Andrew. Yeah, thank you so much for.
He's on the move. Yeah.
Yeah. So if anyone has any other questions, please feel free to add that to the chat. So if not, let's start with Father Joseph. What do you think?
Well, I'm not a lawyer, so I mean, the question about informed consent is very much a legal problem, well, not problem, but legal issue in the sense that in most places, you have to sign that informed consent, right? It's a legal document and has implications for the doctors when they want to operate or treat the patients, either verbally or, I mean, most of the time is operation will be some kind of a contract. So, I mean, there, I think the problem is always how truly is it an informed consent? Does it really fulfill its purpose? Or is it more like a legal protection for the doctors? I mean, that's the thing. So what is how do you kind of like change that that application of informed consent that I think we all agree to make it more like a realistic representation of informed consent rather than making it just a legal requirement. I mean, that is, I think, the crux of the problem there. And then when you bring in all these, I mean, legal reality wants to have something very neat and tidy. But when we bring in all these things about relational autonomy and the culture and family, it is very messy. It's really messy, right? And so how do you bring that in, and how the law can actually take into account of all these kind of messy issues? It's very complicated, right? I mean, it's very complicated. I mean, I think for us, it's easy to say virtue and prudence and precaution and all these kind of things would be the ideal. But then in a very legally, I guess, structure in medicine today, how do you really implement that? I mean, I think that I expect to you. I mean, that's your job.
Thank you. I think it's a great point there. So just to pick up on what you've mentioned, Father Joseph. So I just wonder whether, given what we've heard about the situation in China from Professor Tsang, that, you know, clinicians are essentially relying on the law to protect themselves. So does that ultimately crowd out, in a sense, other values? And it doesn't incentivize clinicians to take into account some of these other values that might come into competition with what would be the sort of values that the law would privilege, for example, individualism, for instance. So with this, Professor Tsang, any comments, please?
Yeah, I think in China, they tend to use informed consent more in the legal sense than the ethical sense. Of course, I'm not a lawyer myself. You know, ethical speaking, we tend to talk about more like ideal situations. For example, we like to say more about, like, say, the virtue of the, you know, medical professionals, or we talk about the kind of rational capacity of the patient, you know, stuff like that. But the problem with some sort of ethical considerations that sometimes we tend to you know, have to make the moral bar a little bit too high, and it's too idealistic. And I think the legal part, from my perspective, tend to be more like a practical, and they really concerned about the you know, the implication. I mean, the implication. I'm sorry, the practical dimension of a certain, how the value can be, you know, accomplished, stuff like that. And I think Andrew asked a question earlier about whether the informed consent itself is a process, because I'm using the term process from the documents, or it's a procedure. it's very interesting. I mean, I think legally, of course, it's a legal procedure, but I tend ethically use the process because the focus point is not the final signature, signed by patients. It's the whole process, how the physician and patients or family, anybody involved can work, in a positive and collaborative way. It takes a process. So that part, I mean, is more important than, the final signature, of course, that is required legally.
Thank you so much, Professor Tsang. So if we agree that informed consent ought to be a process and hopefully somewhat more accommodating of the other values, what then, or how then should we understand relational autonomy? And of course, given all the pressures that we find on clinicians within a hospital or healthcare setting, is it really the right setting for clinicians to cultivate themselves towards the sort of virtues that ought to be demonstrated professionally and also as individuals? So with that, Professor Fan, would you like to comment? Curious about
I would very much
Confucian
like
perspective.
Echo Alan's and Kelvin's points just made. A few years ago, I remember the Chinese Ministry of Health. At that time, I think that's still the official title. The Chinese Ministry of Health issued a document. Chinese administration document often plays the rule of law, I guess, in essential sense. They require that from now on, all hospitals in practicing informed consent must require direct patient's signature. No family representative signature. Family signature does not work. Right now, you must only implement individual patient signature. That kind of administration requirement does not really improve the practice of informed consent in any moral or appropriate way, only cause the chaos, only made these hospitals and doctors troublesome and didn't know how to do that. And the families will always find all kinds of excuses and ways to, avoid the direct signature by the patient and so on and so forth. So I guess the case shows clearly that it's not simple for a society with a particular sick culture to copy a fashionable word like individual autonomy or whatever to use administration or law to impose it on society. It may be much more, useful or reasonable and beneficial to really use some ways to promote communications, really, engage people to consider the culture and local values and rituals and so on and so forth. So I do take, in making laws or administration guidelines, the culture is very important to be integrated to really want to improve informed consent. Thanks.
Thank you so much, Professor Fan. So before I move on to invite Professor Gould to comment, I do see that Dr. James Chew has got a question or comment to share. Dr. Chew, are you able to speak? Okay, that's brilliant.
Yes.
Coming through.
Yeah, I'm sorry, actually, I pressed the wrong button, but since I'm on the air, I think I just want to say that as a mediator, I'm interested in the use of mediation in consent. I think this is an area that we can explore. Thank you very much.
Thanks so much, Dr. Chew. So I'd love to hear from speakers in the second panel as to your thoughts on what relational autonomy could mean, particularly through legal lenses. So that's a question from Dr. Wai-Tat Wong, and also how are we to think about, as Dr. Chiu mentioned, dispute resolution. So does the law promote that? Should the law promote that, particularly given differences in applicable threshold? We have seen this in Professor Gould's presentation. So Professor Gould?
I think one of the things to think about from a legal perspective is that I think it's quite difficult to implement shared decision making legally, right? So it makes a lot of sense as a clinical practice that you would not simply ask somebody to make a decision in isolation, that you would involve their family members who might have legitimate interests to be taken account of, whatever that decision is. So an end of life decision, and you involve the partner and the children and so on, and they're all part of this process of deciding what would happen. And so as a process, it's clearly valuable and right. But when you come to the law, then I think the question is, what does the law do here? And it might mandate that you have to have a process of shared decision making, that they've got to be consulted. That I think would be unproblematic, really. But I always wonder, and I'm really curious to hear what other people think, is, but what happens when you get to the hard edge of a decision? So let's say you have an end of life decision, and the person whose life it is, who's terminally ill, doesn't want to end their life, but other people around them want them to because they're a burden, right? So a really unpleasant discussion. The more likely scenario is the person wants to end their life and the people around them wish that they wouldn't. So their children wish they'd hang on, or the partner wishes they'd hang on, or they're refusing the next possible treatment and they just say, I'm done, I'm out for the count, right? What I'm really curious about is what people who are in favour of relational autonomy say the law should do at that point. Because the English law at this point would obviously say that the person whose life it is would have the trumping vote. And if that's the case, then the law isn't really shifting its approach, because it's just giving them their autonomous choice. It's simply creating a process whereby they have to talk about, but ultimately their decision is the trumping decision. And I'd kind of like to know how someone who wants a really strong relational autonomy approach would see it being operationalized legally, as opposed to just an ethical practice. So I'm basically asking my own question, because my view is, I think it's very difficult for the law to do that, because the outcome would be, if the other people in the shared decision-making process want something different from the person whose life it is, then the only way the law can make it happen is to actually force it on them. And I think the reality of that would be obviously very problematic, and certainly in England that we just wouldn't take that approach. So I've added a question rather than answering one. Sorry, Calvin.
No, that's brilliant, Imogen. A fantastic point there. And of course, I am very happy to invite the practitioners to speak to that, drawing from their rich experiences. I see Professor Leong has got his hands raised. And then, of course, Gilberto, after your comment, we'll hear from Ginny and, of course, Dr. Au.
Yes, sorry to chip in. Professor Good, can the problem be actually lie in the reasonable person test that the English law applies, obviously, after Montgomery, because the reasonable man is supposed to be a monistic, universal person, whereas there are reasonable Chinese, reasonable husbands, assuming there's such a thing, reasonable daughters, sons. If we can expand the scope of this reasonable person concept, we might be able to accommodate a more relational approach to consent. Welcome your comment. Thank you.
Well, let's hear from Ginny and Dr. Au, and we'll circle back to Imogen, in case, Imogen, you've got any more thoughts to add. And of course, our very eminent speakers from panel one. So, so over to you, Ginny.
Okay, so I think there are two parts to my answer. I think the first part is in scenario where perhaps I think even though there could be an appointed decision maker recognized by the law, and they are the person who has the authority to give consent, but I think oftentimes we still see them also consulting other family members. So I give you an example of late. I have this patient, because he is in his 60s and so are his siblings. His siblings actually know him much better than anyone Unfortunately, it didn't make sense for him to appoint someone who is older than him to be his surrogate decision maker because they might pass away before him. So he decided to appoint the younger generation, his niece and nephew, for very practical reasons. So so he has lost capacity to make decisions for himself. His nephew and niece came on board to be the appointed donees, but unfortunately, they actually don't know much about him. So they still circle back to their parents, who is the patient's siblings, to discuss, and then they decide. So, but of course, my question is, what if one day the nephew and the niece kind of fell out with their own parents and they have differing decisions, and they may not know the patient as well? So then I think we have a problem, and perhaps at that point, that's where the law needs to come in, and whether we need to revoke their powers, because if they are not making decisions in the patient's best interest. So I think that's one issue. I think the second point is, Professor Goh just asked the question about what if patient wants to live on, and but the family members say, oh no, he's a burden. I think a lot of times how it plays out is it could be an abandonment case in the hospital. So they end up being in the hospital. We may not, depending on the circumstances, there may not be reasons to terminate care or withdraw the care for the patient. We may end up caring for the patient. Of course, at some point, if the patient does present certain complications, and if it's not in the, if it's really not in medical best interest, and if let's say, of course, if patient still decides to, for example, opt for full active treatment, then I think it might be a bit difficult. I mean, of course, the doctors, to a certain extent, they will have certain limits to their provision of treatment, because if they do not think if there are medical benefits, they are not obliged to provide. But I think oftentimes there could be gray areas, or maybe at some point, if the patient falls into a coma and doesn't have capacity anymore, then the family and the team makes that decision, and there might be a withdrawal of care at that point. So I think this is how I think sometimes it does play out in that sense. Yeah, thank you.
Thanks so much, Jenny. So just to pick up on a point from Dr. Chew, do you see any avenue or space for mediation or relationship building? I think it's especially difficult if we're thinking of abandonment. So that's a very sad situation. But can such things be anticipated?
I guess a lot of times when we have patients with very complex needs, they might be already known to a social worker, either from the hospital or from the community, and especially when there are differences between family and the patient. So we could have already preempt that this may happen sometime down the road. And we might also keep tabs on how the patient is coping at home, especially where there are disagreement about the care of patient. Yeah. As for whether there's a place for mediation, I think a lot of times we tend to try and manage it at the primary team level. So if it's something, if we can build relationship with the patient and the family, then there may not be a need for independent third party to come in yet. Yeah.
Okay, that's brilliant. Thank you so much, Jenny. And with this, Dr. Au, it's over to you. Final pronouncement. You may want to comment on this whole notion of reasonableness. I think it's currently being disputed in the chat as well. The point that Gilberto mentioned.
Yeah, I think that's an interesting idea if you stretch the reasonableness a little bit to say reasonable daughter, reasonable wife, spouse, and so on, and then sort of insert the relational autonomy idea into that process. But I think my general thinking is more like Professor Goh, I think, in that I can't see easier way to operationalize either shared decision-making or relational autonomy into a legal process. I think really realistically, we have to slightly separate what I call the formal process or procedures with the informal and clinical process. And shared decision-making and all the good practice belongs to the soft process. Communication skills belong to the soft process. Social workers' ability to resolve conflicts are in the solve process. So if you want to use the law as a simple instrument to formalize some of the elements into the legal process, I think that would be quite an uphill or perhaps impossible task. The other and final thought that I have is that really, I think there's another way to phrase the problem of the present situation of individual autonomy without invoking a complex relational autonomy idea. And that is, as Alan pointed out, the present mode of practice framework has freed us from the tyranny of paternalism from the old days. But now it seems that we are moving into a sort of tyranny of the legal procedures, which is getting really worse after the Montgomery case, even for Hong Kong. It causes quite a stir in Hong Kong, and then people step up the formalistic elements in the informed consent procedure in response to the Montgomery case, and makes life even more harsh or difficult for frontline clinicians. And it doesn't really help the informed consent process either at the clinical level. So I think really, as I see the challenge, perhaps without inviting physicians to talk about relations of autonomy, is to see if there are ways and means by which we can free ourselves a little bit from those excessively legalistic, perhaps defensive process. And I'm thinking the role of institutions. We can talk about clinicians and the law, but really institutions, the hospital authorities, the hospital management are really important. Clinical ethics committees are really important institutional parties that can help interpret the gist and essence of the law to make sense for clinicians to work in form of guidance, of guidelines, of consultations, and so on. So tonight, I think we haven't really touched on the issue of institution in between the law and the individual clinicians. And perhaps it is at this level that we can hope to incorporate some of the good concepts and values and ideas into guidelines and practice and trainings for clinicians. Thank you.
Thank you so much, Dr. Au. I guess we have the theme for our next webinar that's been set out for us. So let me circle back in the interest of time to Professor Gould, and then, of course, to speakers in panel one, so that we can round up at least for today, and then, of course, save a number of these important points for future sessions. So it's back to you, Imogen. Have you got any responses in relation to, of course, what Gilberto has mentioned on reasonableness, and then also, I think, point well taken in terms of distinction between formal legal process and institutional ones that perhaps may be a bit more accommodating of other values that we find in the community?
I think the thing I did want to say, I guess, now I get another chance to speak, which is good, is I think Dr. Au is absolutely right. We see the same with Montgomery here, this really defensive practice now, that it's not been taken in the way that was meant to, in a sense. The reasonableness dimension there is meant to be turn your mind to questions that you might imagine people generally might want to know in this situation. I think that's its intention. But it's certainly, we see the same thing, this quite formalistic process of doctors feeling really unnerved now that if they don't go through this process, then they will be back-footed and they will potentially be in breach, and that's a problem. So we definitely see the same thing. So I think on that, we're absolutely in agreement that that's our big issue too.
Thank you so much. Let me circle back to speakers on the first panel. Have you got some last words, final comments? Professor Fang.
Yeah, I'm a little bit confused about the last question. To me, the difficulty is an ethical one. The difficulty is not we cannot logically to make different laws. Of course, we can make all kinds of different laws in quite different content. For example, you could make laws that absolute individualist authority, right? The patient has the final word, period. Or you make the law like, a patient must, together with a family member, immediate family member, have the final word. Or you can even make law like consensus. All family members must get agreement before you can do anything. So all these kind of laws can be made. There's no problem, no logical problem. The difficulty, I guess, is the ethical difficulty, normative issues eventually. What is the right form of law we should make in consideration of different cultures and different social realities and so on? Thanks.
Thank you so much. Yeah, so whether that's attainable, that's a big question. So I do wonder whether Professor Tsang and Father Joseph would want to weigh in on this point.
Well, I think I agree with Wei-Ping. Sometimes we live in a very legalistic society, and sometimes we forget about the ethics should come before law, right? Laws are made after we find out that what is the right thing and a good thing to do. And sometimes we lose sight of that because law sometimes is used as an instrument. And it's kind of like a easy way out. So we have to kind of go back to the ethics. That's my final comment. So.
Thank you so much. Professor Tsang, any last comment or point?
Okay, my last comment is that think about the old model, physician and patients. We talk about more like a paternalistic or parental model, and in that kind of situation, I think the most important thing will be trust. We trust in the professionals. The patient has trust, but now nowadays we talk about the rights of the patients. We talk about the egalitarianism. I mean, a lot of definition can be, trust can be, it can be fuzzy thing, but now because we talk about more individualistic autonomy and everything, so we do need some kind of clarification, we need measurement. So that's why I see why, legality plays such important role today.
Thank you so much. Great points there. So
Yeah.
I think ultimately we're ending off on a jurisprudential note. So certainly an important issue for us to continue to think about. In response to Dr. Chiu's comment, we will be looking into mediation-related issues in future webinars, so do stay tuned. Of course, hopefully we'll get to hear from Dr. Chiu himself, who's an expert in this particular area. So that said, Professor Leong, any final words?
Well, I think this, for us to decide what's the next webinar is going to be on. We have many ideas now, so I think we should go and have dinner, and then we'll think about it and have another webinar in the very near future. Thank you so much, everyone, for joining.
Okay, yeah. So final note of thanks to all of our brilliant speakers. I've learned a lot from this session. So thank you so much. I look forward to being in touch. And also thank you to all of our participants. You have been hugely generous with your time. Thank you so much. And we look forward to seeing you in the next session. Have a very pleasant day ahead, or otherwise evening. Thank you again. Goodbye, everyone.
Goodbye. Thank you so much. Thank you. Bye-bye.
Thank you, everyone. Bye-bye.